Good morning and welcome. Thank you for joining us for the first episode of the BIICL Human Rights Due Diligence Forum's four-part webinar series on human rights due diligence for climate change impacts. I'm Lisa Smith and I'm the director of the BIICL Human Rights Due Diligence Forum. So this topic first came to our attention as requiring further consideration last year when we were undertaking a study for the European Commission on regulatory options for mandatory human rights and environmental due diligence as a standard or a duty of care. It was clear from the mandate of that study that any such EU law would apply to companies' climate change impacts. Human rights due diligence as a standard or a duty of care is based on what can reasonably be expected of companies. And it is not clear, became obvious from the study that it is not currently clear what this means in the context of climate change. The findings also show that companies' processes for due diligence for climate change and for human rights have been developing in silos for the most part to date. So the study has since formed the basis for the launch of an EU legislative initiative announced in April 2020. And for the purposes of this webinar series, we work on the assumption that there will be such a due diligence standard of care at EU level and elsewhere. We want to bring together the experts to start asking the questions that will inform the design and implementation of these new generations of laws. Given the state of the climate emergency, it is in everyone's interest that once we have these new legal duties, all stakeholders have some clarity as to how they apply to climate change, including companies' internal decision makers and managers, their legal advisors, policymakers, judges, regulators, rights holders and claimants, investors, and civil society. Today, we are asking what can we learn from the status quo, the law as it stands, and existing experiences. In the second episode, we look at climate change litigation and how that has and may in the future inform corporate due diligence on climate change. In the third episode, we look at the legal duty itself and how it is likely to apply to climate change impacts. And in episode 4, we look at practical advice, predictions, and tips as to how companies and other stakeholders can implement the future laws and meet the standard of care. So without further ado, I will now hand over to my colleague Ivano Alonia, who is our expert in environmental law and climate change law. Thank you so much, Ivano.
Thank you so much, Liz. I'm Ivan Alonia. I'm a research fellow in environmental and climate change law at BIICL. I would like to welcome you all to this webinar on this timely topic of corporate due diligence for climate change impacts and its status quo. It is wonderful to see so many participants here today, in addition to our excellent speakers. Thank you all for joining us and for your interest. Today we have, as you will see, a very heterogeneous panel, and I'm looking forward to listening to their contributions. We will reserve questions for the speakers at the end of all presentation. You can write your question at the Q&A button on the right hand of your screen. We will start now with a video presentation by David Boyd, the UN Special Rapporteur, Human Rights and Environment. Living on the west coast of Canada, this session was a little bit early for him, so he kindly sent us this video. And thank you again, and enjoy David Boyd's video. There is some technical problem, but we are coming back very soon with this video. Okay. Yeah, here it is.
Ivano, I think you are muted. I was wondering of whether we should start with the panel, and then we
Yeah,
could place the recording on a link for participants to watch separately. Is that okay?
yeah, absolutely. So let's start with our panel, then we will retrieve David Boyd's video. So our first speaker is Shona Oakes. She's a senior global policy advisor for Forest at Global Witness. Shona has over a decade's experience working in support of communities protecting the land, forest and water rights, and has led policy and advocacy work at local, national, and international levels at the nexus between human rights and safeguarding the environment. At Global Witness, she advises on strategies to address the financial behind forest destruction and its role in the climate crisis. Welcome, Shona. You have the floor for the next 10 minutes.
Thank you so much. It's really exciting to be here as on this panel. I think I have to say the caveat that I'm not a lawyer, and also that these sorts of law reforms are something that many of my colleagues at Global Witness are also working on. So what I was going to do today was just to give a little bit of an introduction to what communities need and who are these laws for. So just on the screen, hopefully you can see my screen, it's just a quote from a report from a group called Frontline Defenders. And what this shows is that land and environmental defenders, particularly Indigenous peoples, are the most targeted group of human rights defenders. So when we talk about the environment, when we talk about climate and we talk about human rights, some of the tactics and the strategies that we use may be different, but they're all part of the one ecosystem. They're all part of the interconnected nature of the social and the ecological world. And so up on your screen now, you'll see a copy of a report that Global Witness puts out every year. And what this does is it tracks the killings and the threats to land and environmental defenders. And what we're seeing is that those threats are escalating. 2019, we had the highest number of documented killings of environmental defenders. And that's just the data that we're able to collect. And of those killed, 40% were people from Indigenous communities. So Indigenous peoples comprise about 5% of the global population. So when we think about who are these climate laws for, who are these environmental laws for, these are the people who most need them and should be able to most use them. The other thing, I think, as Global Witness's team that work on the defenders work, one of the things that they've observed is it's important to document the threats to defenders. It's also important to focus on their successes in what they're defending. But also the bigger picture is to reduce the threats of people who are fighting for the environment, who are fighting for their land. We really need to tackle the business models behind them. And so what had, as a human rights activist, what I've seen recently, and I'm sure many of you have too, is people who are in the human rights space. A lot of my friends are now working on climate issues because we understand that you need to use whatever tactics will work, and tackling the business model is the best preventative strategy in a lot of cases. So I started thinking about a little bit of a wish list of thinking about what myself and other colleagues have seen in recent years and what that means for how we think about future laws. So one thing is when we talk about climate change, that is also an ongoing live process of how we respond to that. So what we're seeing is a global shift from a fossil fuel-based economy to a land-based economy. And a lot of the structures that we're seeing companies adopt are really focused on fossil fuels, which is obviously incredibly important. But as the IPCC and others are pointing out, we know that there's other high climate impact industries, deforestation, agribusiness. They're also obviously having a huge impact on climate and also the people who are trying to defend their land and environmental rights. One of the other challenges that we see with those structures being quite oriented to fossil fuels is we have this focus on net data, on aggregate data. So what is a company's total carbon emissions? That works to a certain extent if a company builds a coal mine. You know, it's going to know basically what its emissions are going to be based on the contribution of the core product that it's dealing with. The problem is we also see a lot of climate impacts from companies that don't have anything on their books about emissions. So one of the areas that I look at is agribusiness. And we know a lot of companies are on the books on not having any links to deforestation or any links to sizable impacts on local habitats, but they still happen, they still occur because they're not doing adequate due diligence on that. The other key point that I think the climate space can really learn from the human rights space is it's great that a company reports on its net exposures, but it's even better if a community knows what companies are connected, what businesses, what financiers, what buyers are connected to what's happening on their land or in their community. And then they can talk to those companies. They can talk to the companies who are doing business with them. They can understand what their climate change policies are, what their human rights policies are, and they can access the rights under those policies. And currently that's really where a lot of the system breaks down. And I guess the third trickier question, I think, is something that we're dealing with in the human rights space, which I think also applies on climate as well, is if we're thinking about some sort of liability or accountability for climate change for companies, what does that mean for supply chain actors? So to give an example on the human rights space, if a company commits abuses on the ground, but that company has been supported and financed by others who have profited from those activities that have not done their due diligence, how do we figure out the liability of investors or banks or buyers and make sure that they're included in those questions as well? I guess the other big picture point, which I'm sure other speakers will talk more about, is that we need a system that looks that is focused around businesses being accountable to their contributions to climate change and to environmental harms, and not what climate change costs their business. So it's great to see that we have had some evolution of a lot of the discussions about how coal or fossil fuels may impact business, but we need to keep in mind that they took half a decade to evolve, and it's much better that we focus on what businesses are doing to the climate and not how it's affecting their bottom line. And I guess in that point as well, no surprises, but we need something that meaningfully costs business. We need to ensure that there are adequate deterrents so that, you know, paying penalties or fines doesn't just become part of the, you know, the cost of doing business in certain industries. The other point that I would really stress in thinking about this in any context, I know some of my colleagues are looking much more closely at the EU, is to aim for legislation that can complement the legal strategies which are used by grassroots activists in their own country and context. So climate change, and that's obviously a very salient legal framework in some contexts, but just to keep in mind that at minimum we shouldn't be closing the door to other legal frameworks, and ideally we should be trying to incorporate and build on them. So in some places this might involve looking at the OECD guidance on responsible business conduct. We know that the rights of nature is a framework which is coming up. Ecocide, in some places biodiversity is very salient and might be more salient than, say, climate, so how we incorporate those aspects, or other environmental laws. And I know that as an Australian as well, we're also looking at some exciting legal cases around torts and duty of care as well. So just before I finish, I think, I personally also get a lot of inspiration from legal scholars who have a lot more expertise in looking at this holistic approach to the law. And one of my favourite legal scholars is a woman called C.F. Black, who's a Kombumerri woman from a First Nations group in Australia. And she really talks about, when we think about governance, when we think about the power of the law, what we really want is rights, responsibilities, and relationships. So any legal framework that helps us to not just look at people's rights to the environment, the responsibilities that companies and others have to the environment, but also how we can look at frameworks which encourage and foster relationships, conversations, to get beyond quite an extractive mode of doing business where no one knows what any other parts of the chain are. So thank you very much for that. It's really exciting to be part of this discussion, and I really look forward to learning more from the other speakers as well.
Thank you very much, Shona. And now we are trying to go back to the video from David Boyd. Liam, if he's ready. We try. There is no audio. Okay, so probably we continue and we will use this video at the end. Sorry about that. So our next speaker is Clotilde Henriot. Clotilde is a trade lead and senior law and policy advisor. She's been working at ClientEarth since 2013. And in particular on the implementation of legal instruments to reduce the drivers of deforestation. For the last year, she's been working on EU initiatives that aim to regulate imports of forest risk commodities. And finally, she has been also developing legal analysis of the type of legal instruments needed to strengthen corporate accountability in global supply chains. So welcome, Clotilde. You have the floor and for the next 10 minutes. Thank you very much.
Thank you very much, Ivano. Hello all. So the idea with my presentation today is to give you an overview of the current legal framework which exists in the EU and in France as well in relation to due diligence for climate change impact. And I will finish my presentation for food for thoughts, basically, on the raising questions for any upcoming legislative proposal on due diligence for climate change impact. So I will start by, voilà, to give you the state of play of due diligence for climate change impact, like I was saying, by not giving you all the existing legal framework, but some of them. Before entering to some explanation around the non-financial reporting directive, I thought, even though you are all quite familiar, I imagine, with the concept of due diligence, still to go back to it so that we do understand why a due diligence requirement will differ for disclosure on climate change impact. So basically, based on the OECD guidelines for multinational enterprises, the concept of due diligence involves a bundle of interrelated processes to identify adverse impact, prevent and mitigate them, track implementation and result, and communicate how adverse impact are addressed with respect to enterprise own operation, their supply chain, and other business relationship. I think it's important to try to keep this type of concept in mind when we talk about due diligence, because there is a big element which is on the prevention element, which is a bit different when we are talking about reporting, when unfortunately the negative impact could have already occurred. So basically, we know that some progress have been made, however, on disclosure in relation to climate change impact, notably thanks to the adoption of the non-financial reporting directive in 2014. Member States had 2 years to transpose this directive into their national legal framework. Obviously, then it will differ in each member state on how, if they keep exactly the same scope of companies or if they have broadened it a bit, but it's supposed to be targeting large public interest companies with more than 500 employees. It seems that it means that it targets approximately so far 6,000 large companies and groups across the EU. And the question is basically with this non-financial reporting directive, what is the idea? The idea is to provide some information in relation to environmental matters, social and employee matters, respect for human rights, anti-corruption and bribery. And when we look at the type of information that should be given, I think it was interesting to notice that there is indeed, when you need to give a description of the policy pursued by the undertaking in relation to those matters, the fact that there is the mention of any type of due diligence processes implemented. So that there is no confusion, it doesn't mean that that companies have to implement a due diligence process. They just have to report on it if they have it. So that's a bit different. Then I thought it was quite interesting as well to look at another component of the information that should be given in the non-financial information statement, where it does say that the information should be on the principal risk related to environmental, social and employee matters, respect for human rights, anti-corruption and bribery matters, linked to the group's operation, including where relevant and proportionate, its business relationship, product or services, which are likely to cause adverse impact in those areas, and how the group manage those risks. So that's quite interesting because we are really in the core of the due diligence requirement, because it's basically an assessment of the risk and the impact. And here we see that there is at least the need to disclose the type of information in relation to those risks. And there is this interesting also component of the description of the management of those risks. Unfortunately, at this stage, it needs to go a step further than having the idea of managing the risk. I think from the definition I gave at the very beginning, what was interesting is to be able to understand how, when there is a due diligence requirement, how the company will mitigate those risks, and also how it will take it into consideration before making any business decision. So this disclosure requirements are a first step. Unfortunately, particularly in relation to climate-related risk, there has been a study done by the Alliance for Corporate Transparency Research in 2019, which demonstrates that so far only 46% of all companies, they have assessed around 1,000 companies, don't provide any information on climate-related risks. And I think even though obviously this figure is disappointing, I think there is now better sign also on how companies can do better and how they can inform what they put in their non-financial information statement by the production from the European Commission in June 2019 on guidelines on reporting climate-related information. I think it's important to know that those guidelines integrate the recommendation of the Financial Stability Board Task Force on Climate-related Financial Disclosure, TCFD. And I think it's also important to know that those guidelines do provide a set of examples of risk negative impact in relation to climate. I will now also talk very quickly about what we have with not a disclosure requirement, but the France has gone a step further by the adoption of the French Duty of Vigilance law in 2017, where basically companies, the scope of companies which have to have a certain number of employees and a turnover which are quite high. However, those companies must include due diligence measure to identify risk that within their operation or the operation of of their suppliers, there can be severe impact on human rights, fundamental freedom, health and safety in person, and the environment. It is a quite broad provision. We don't have yet any secondary legislation in France which detail the meaning of the impact on the environment. And but however, obviously it should be assumed that it encompasses climate change impact. There is so far some ongoing now litigation in France in relation particularly to the scope of the legislation, especially in relation to climate change impact and how it should be integrated into vigilance plan. So we can have some hopes that we will have more detail on the type of responsibility and obligation on how to address and mitigate those climate change impact when they are identified. Finally, still on this French duty of vigilance law, there has been in March 2020 a study which has been released which have identified that 10 companies out of the 25 which were scrutinized do not integrate climate in their diligence plan. So we can see from the current legal framework that there can definitely be still some improvement for a strong due diligence requirement in relation to climate change impact. I think now that we know that we need more, and the idea will be in the coming weeks, in the coming months, to continue to think about one of the key questions in relation to corporate due diligence for climate change impact. I think, like I've said before, there is the key steps of due diligence around the identification, the assessment, and the mitigation. I think it's extremely important to understand that the due diligence system is proactive. So a forward-looking function that identifies potential risk and inverse impact before entering into any business decision, but it should also be a reactive process. So basically due to mitigate the impact which have occurred. And I think also one of the things which are going to be very important is how we manage to define a climate change risk. There are thankfully a lot of guidance document principle, and I think there is a lot of good basis to touch upon how this can be defined and to define it, and obviously it should go hand in hand with human rights. The last thing I will say is that we have seen so far for the French duty of vigilance as well as for the non-financial reporting directives that the scope of company, the threshold is quite high. So we also need to assess if what type of threshold is really needed if we want to ensure that companies address correctly their climate change impact. I will stop there. Thank you very much.
Thank you very much, Clotilde. A very interesting overview also of the French case, and we pass immediately to the next speaker, Caroline Sloan. Caroline has a special interest in business, human rights and sustainability with a focus on the finance and energy sector. She also teaches courses on environmental sustainability and social responsibility. Caroline's interest in the field of business human rights developed during her time as a lawyer in the oil and gas industry, where she specialized in oil and gas finance. She has worked with the IFS and commercial banks on the funding of international oil and gas developments in sub-Saharan Africa. So welcome, Caroline. You have the floor.
Thank you. I'll just unmute myself. So good morning, and thank you to Ivano and Lise for this opportunity to share some observations. I'll just share my slides if I can do that. There we go. Hopefully that's working. So I'm going to look this morning at industry practices from the oil and gas industry, in particular, because that's the sector I know that might inform a due diligence standard, looking at problem areas and themes, and trying to examine where climate change impacts can be better reflected in terms of human rights standards. In the last months, we've seen quite a range of statements from a number of the European-based energy majors, particularly BP and Shell, stating how they're going to approach their reduction of carbon emissions, particularly in line with the Paris Agreement. And those are problematic, of course, in places, but it is a bit of a change of tone, if you like. And what I would hope that we can see develop from those sort of statements, if we're talking about setting global standards, is some kind of expectation around companies having a climate change policy that reflects how they will tackle their emissions to get to net zero in line with the Paris Agreement. And if oil companies are getting on board with that, then surely that opens the door to other sectors as well. However, moving from words to actions, the climate change the way that oil companies and energy majors are addressing emissions is quite variable, of course. However, it is possible to see areas of focus, areas of behaviour and activities that many of the European-based companies are engaging with, and that from that, I've kind of compiled a list here, which you can take a look at your leisure, which really tries to show where in the future we might be able to say, well, these are kind of expected standards of behaviour, and to then pick out companies who are not keeping up with their competitors, and say, well, maybe these are companies who are excessively emitting, if you like, and maybe Jaap can speak a little bit to that in relation to the climate change principles. So that we know that climate change needs to be tackled urgently. As you can see from the list, many of those are focused on production, and really the focus needs to be now on the 86% or so of carbon emissions that come from the consumption of fossil fuels. So the kind of perspective, I think, within the industry does need to change, and the guidance and documentation and legislation that we have needs to really address that part of emissions. I'm going to turn now to climate change impacts, and the taking a climate change lens, looking at how climate change impacts on human rights due diligence might be approached, and the areas of concern, but specifically in relation to the energy sector. So looking at kind of where people start when they start with a human rights due diligence exercise, that's typically with a risk mapping exercise, and that's in line with UNGPs at Principle 18. And the Total Vigilance Plan gives us a real window into what in practice they do and what other companies in the sector do in terms of mapping exercise. And I think what we can see is that, and this is a recurring theme actually, that there isn't really a climate change lens necessarily being applied. There isn't necessarily a reflection of climate change impacts in that risk mapping exercise and elsewhere in the process. Moving on then from the risk mapping exercise to impact assessments. Impact assessments are carried out widely through the industry in terms of a requirement by law before beginning any operations on the ground in host states. So the industry is very familiar with these, and they look at the social, environmental and health aspects of the impact of the project, but they aren't necessarily human rights compliant. If they're meeting legal requirements, they aren't necessarily a human rights impact. Increasingly, however, that does happen, as we see from the IFC performance standards and the Equator principles, which kind of import IFC performance standards into commercial lending for projects. So I won't run you through in too much detail how you do a social, environmental and health impact assessment, but just to say that these tend to be very, in terms of the environmental side, they're very site focused. So they have certainly historically really struggled to address something like a cumulative global impact. That's not to say that there is no climate change impact assessment going on as part of a wider impact assessment process. I can think of examples. For example, a situation in sub-Saharan Africa where the operator conducted scenario planning with the use of experts to do that for them in order to help locate infrastructure in a known water stressed region, and to work out, well, where can we put this infrastructure so that it does not add to the existing water resource constraints, nor will it do so in the future in the event of temperature rises. So that does happen. However, that's not necessarily what's happened in the past, nor is it a kind of global approach. It is not exactly set out in guidelines as a requirement from an industry perspective. We see BIICL, the body that helps to set kind of provide industry guidance on social and environmental issues. They refer to climate change impact assessments in their guidance, but they don't elaborate on it at all. It is going to start to be required under the Equator Principle, so banks will start to expect companies to conduct climate change impacts in some cases on new projects. However, that approach uses the TCFD as an underlying framework. The Task Force for Climate-Related Financial Disclosure is a disclosure project. It is also aimed at investors and informing investors. So there isn't a human rights approach there. There isn't a human rights lens on looking at scenario planning, and that's something that needs to be brought in to help make that area of impact assessment for climate change work better. Thinking again then about how we prevent actions under the UNGPs, that's quite often about relating to your suppliers and your contracts. And in the oil and gas industry, the environmental contracting side is very technical. It's often focused on design. And it's very much an area where we see the industry working in silos, with the environmental piece done in one place and the kind of human rights side done in another. So if there's screening happening for human rights, it won't necessarily incorporate yet thinking about climate change impacts. And so that's an area where we really need to see the contracting process brought under a kind of climate change lens, and to see the environmental and the human rights processes joined up more effectively to tackle that kind of cumulative effect and impacts side of climate change. Finally, on stakeholder engagement and operational grievance mechanisms, it's kind of an open question how you're going to deal with stakeholder engagement on climate change impacts. This is a particular area of concern for me in relation to fragile states and areas where there is ongoing conflict or have been areas which are post-conflict, because the oil and gas industry tends to major in operations that happen in these places, and so we need to examine afresh what is best practice for stakeholder engagement and for operational grievance mechanisms. What do we need to change in order to take account of the climate change impacts that may or have or will occur in the region, and how that will affect, for example, how you engage with your stakeholders better, who you engage as experts, because they'll need to have an understanding of the, because they will need to have an understanding of the climate change perspective, who you engage and how you engage on independent monitoring, for example. So there's a whole raft of questions around operational grievance mechanism, operational level grievance mechanism, stakeholder engagement, that needs to take account of the fact that climate change impacts will exacerbate conflict and will cause their own complications for fragile states. So in conclusion, there's lots of open questions and areas that need development within the industry, and there are particular areas that the industry kind of brings into focus, like the fragile state case that I've just mentioned. I think the ongoing perspective on how we deal with existing infrastructure and existing sites is a big issue for climate change impacts, and I think there aren't any easy answers, and what we really need is a much more collaborative approach, which involves engaging a range of experts, NGOs, and people who can really work together from different areas of expertise to inform what climate change impact should bring to the picture of how we address human rights. So lots of questions and lots of answers that need to come in due course. Okay, thanks very much.
Thank you very much, Caroline. Indeed, a lot of questions, a lot of answers. And that's why we are trying to be a little bit faster. So we leave the time to the attendees to pose, to ask these questions. So our next speaker is Stuart Bruce. Stuart is a senior associate in the International Arbitration Practice Group at Wilmer Hale. He focused on international commercial and investment arbitration and public international law matters across various sectors. And he has a particular interest in environmental-related issues. Indeed, his part his practice as counsel, Stuart is currently an expert reviewer for the IPCC for coming 6th assessment report, and is vice chair of the International Chamber of Commerce UK Energy and Environment Committee. Previously, Stuart was a research associate at the Cambridge Lauterbach Center for International Law, and he worked for the UNFCCC Secretariat during the early stages of designing the Paris Agreement. So welcome, Stuart, and you have the floor.
Thank you very much, Ivano, Lisa, and my co-panelists. It's a pleasure to contribute to this delocalized space today. I will say a few words about climate change due diligence in the context of investor-state dispute resolution, ISDS, or investment arbitration. In particular, I'll focus on the current potential for counterclaims to enforce human rights and climate change due diligence obligations and standards, such as those mentioned by my co-panelists. One caveat to my presentation is please keep in mind that much of what I discuss could also be relevant to challenging jurisdiction and admissibility and even the merits, according to some cases, of the investor's primary claims, but I'll be considering these issues from a counterclaims perspective as an alternative. I'm currently finishing a paper on this topic with Maxi Scherer, so stay tuned for an extensive assessment. But for the moment, I'll provide 2 background comments and get into the detail of one particular area. So my first background comment is simply to note that until relatively recently, counterclaims were uncommon in investment arbitration and are actually still infrequently used. Therefore, the jurisprudence in this area is very much under construction. And there are pros and cons to this. There's not a whole lot of guidance, but at the same time, there's perhaps some room to be creative and innovative in our legal thinking and the way we use this area to implement and enforce climate change obligations. The second background point is to note that of the handful of counterclaims that have been brought, only a few were successful. And 2 of those that were successful involved environmental considerations. That's the Burlington, Ecuador case and the Parenco and Ecuador case that you made. Some counterclaims that were unsuccessful also involved environmental considerations and indeed human rights considerations, such as the David Avon case and Abassa. So there's a small but growing body of environmentally focused case law to interrogate. The stream of cases will no doubt grow as the world pursues more and more climate action, and disputes inevitably arise out of that action. So counterclaims thus present a new and underexplored area for climate change due diligence and investment arbitration, which brings me to my third and more substantive comment. To successfully bring a counterclaim, a state will need to do 2 things, 3 things rather. They'll need to show that the tribunal has jurisdiction over the counterclaim through an express or implied consent in a BIT or legislation. This is definitely surmountable. They will also need to adhere to procedural and substantive rules. This is actually quite important because typically there requires a degree of connectedness between the investor's claim and the counterclaim. But for today's thought experiment, I'm going to assume that's been satisfied. And the third element is to establish a cause of action on the merits, showing that the investor breached its obligations under domestic or international law in relation to climate change and human rights due diligence, for example. And whether it's domestic or international law to establish a cause of action very much depends on the wording of the BIT. And this is, of course, where climate change due diligence could potentially come in. I'm going to focus on this third limb just a little bit more. To establish a cause of action and a breach of domestic law, it could be possible to argue that the relevant investor failed to comply with the host state's environmental laws, including any due diligence obligations related to climate change and human rights. In making such a claim, one would have to consider whether under the BIT, breach of a domestic law obligation alone is sufficient amount to a breach of the BIT itself, or whether something more is required. For example, whether the BIT either expressly incorporates the domestic obligation in the BIT or contains something like an umbrella clause for domestic law obligations, elevating breaches at the domestic level up to the international level. And cases such as Oxus Gold, Rusalis, Anglo America, and Rusuro have looked into these sort of issues that you could explore further. 3 cases relating to counterclaims have found that a host state's domestic environmental laws had or could be incorporated into the BIT itself. And that's the David in Costa Rica, Burlington and Parenco cases. This approach is also likely to be much easier under sort of the next generation, the new generation BITs, which have been recently negotiated or currently being negotiated, because they tend to include an express or implied incorporation of domestic law obligations into the BIT. A good example is the Iran-Slovakia BIT, which states that the respondent may assert as a counterclaim that the claimant has not fulfilled its obligation under this agreement to comply with the host state's law. So there's an express hook there to the counterclaim and domestic law. The Indian model BIT could also be an interesting example. It's very broadly worded in relation to compliance with domestic law obligations, although it doesn't expressly refer to counterclaims. Other treaties which could also be used and have been discussed in counterclaim cases are the DR-CAFTA, the Australia-Hong Kong Investment Agreement, and the Hong Kong-Chile BIT. Establishing a cause of action and breach of international law obligations owed by an investor is a little more challenging conceptually and practically for the simple reason that few international obligations are imposed on non-state actors such as investors. But how could it be feasible in a BIT context? Well, there are at least 2 possibilities. A BIT could contain a provision that stipulates the obligations owed by the investor, such as CSR, environmental obligations, or the BIT may incorporate by reference other international law obligations that it deems to apply to the investor, such as not to undermine the UNFCCC or its Paris Agreement, or international labour standards or the OECD guidelines and so on. So they take on the status of international law by incorporation. But I'm going to focus on the first category, articulating investor obligations in the BIT itself, and I'll use the Morocco-Nigeria BIT of 2016 as a case study to do so. This BIT is signed, but not in force. So what I'm about to say has not been tested. The Morocco-Nigeria BIT sets out both pre and post obligation, post-investment obligations of the investor, which could have implications for climate change due diligence. One of the pre-investment obligations is found in Article 14, which mandates the completion of an environmental impact assessment and requires the precautionary principle to be used in that environmental impact assessment. Both of these tools are highly relevant to climate change issues, as we've already heard, especially in the context of the uncertainties and the magnitude and timing of certain climate change impacts. One of the post-investment obligations is found in Article 18, and this requires that certain types of investments maintain an environmental management system in accordance with the ISO standard 14001 or equivalent. Now, this essentially creates an ongoing environmental due diligence obligation. The ISO has issued guidelines about how climate change falls within that standard, thereby potentially providing an avenue to bring climate change issues into the arbitration, especially if the obligation is also coupled with a domestic climate change due diligence obligation on the part of the investor. Article 18 also creates an obligation on the investor to not manage or operate investments in a way that circumvents international labour, environmental or human rights obligations, which are owed by the home and the host state party. So really broadening out the span of obligations. This essentially renders the investor a participant in the protection of those obligations under the BIT. It's a customary international law obligation for states to undertake due diligence for major projects that could cause transboundary harm, and similar obligations exist in many treaties, such as the ESPO and the Aarhus Conventions. So it could be possible to argue that under this BIT, the investor would be treaty bound not to interfere with any such obligations or with any measures that implement them domestically. And this very issue arose in Cortec Mining in Kenya, where the investor's claim was dismissed on the merits as it failed to conduct a proper environmental impact assessment under Kenyan law and other reasons as well. This particular issue could also be caught by the Article 14 pre-investment provision under the Morocco-Nigeria BIT that we just discussed. Finally, another post-investment obligation is created by Article 19, and I think this actually holds considerable latent potential for broader use. It states that investments shall meet or exceed national and international conjunctive accepted standards of corporate governance for the sector, in particular for transparency and accounting principles. So on the face of it, this provision could potentially be interpreted as applying to both internationally accepted voluntary corporate governance standards, codes, best practices, recommendations, and mandatory standards in national law and regulations. Climate change, due diligence, and climate risk governance are relevant to both categories, as we've just heard. Specifically, in 2017, the TCFD, which has been mentioned today, made many recommendations that squarely target corporate governance, including directors' duties. Those recommendations are currently voluntary and are more or less internationally accepted standards, which is arguably enough to require compliance with them under the BIT. But in any event, even if Article 19 does require mandatory standards, the TCFD's recommendations will soon be mandatory in many jurisdictions, including in the UK. Thus, managing accounting for climate risk as a component of corporate governance will become a legal responsibility under domestic law for boards of directors. The board's obligations will include ensuring that climate change due diligence is undertaken for planned investments and attesting that corporate reports incorporate climate-related disclosures. So because of Article 19, boards may also be required to do the same thing under international law. And that is how climate change due diligence could potentially fall within the scope of the BIT's corporate governance provision. So to conclude, if this Article 19 provision or similar was incorporated into the BITs of major economies, especially those pursuing mandatory climate corporate governance reporting requirements, not only climate due diligence, but climate risk management could potentially become a binding international obligation on investors. Thanks very much for your time.
Thank you very much, Stuart. Thank you very much. It was very interesting. And if anybody has a question on this, on the other contribution, please use the Q&A function. I see there are a few of them, but we still have time. So our next speaker is Jaap Speer. He was attorney, company lawyer, professor. He's a very long CV. He served as Advocate General in the Supreme Court of the Netherlands. Jaap is, among other positions, Senior Associate of the University of Cambridge Institute for Sustainability Leadership. Jaap is also founder and honorary president of the European Group on Tort Law, and he was one of the co-founder and reporter of the group that issued the Oslo Principles and of the expert group on principles on climate change obligation of enterprises. He's currently working in an update of the principles on climate obligation of enterprises, and he also will speak about this. It's a real pleasure to have you join us, Jaap. Jaap, you have the floor. Thank you.
Thank you very much indeed. Thank you very much indeed. I don't think it works. No, does it? Okay, well.
You're sharing your slides?
I don't have slides.
It's working then. Please, you can speak.
Okay.
Yep, you can go ahead. We can hear you and see you.
Okay.
Thank you.
Thank you very much indeed, also for organizing this exciting event. It's commonly accepted that the world is heading towards catastrophe if we don't keep climate change below 2 degrees and, if possible, below 1.5. But sadly, very few players are really keen to translate this commonly adopted goal into concrete steps to be taken by states, enterprises, and other major players. And we really need to concretize the discussion. If you don't have a clue about your obligations, you can't comply. You can't assess whether others comply. With due respect, meaningful disclosure is also difficult. And if you don't comply, you may run a liability risk. There are ever more very credible people who sound the alarm that liability for damages is in the air. Personally, I strongly believe that we should focus on prevention, but ever less people do. An international group of experts tried to map core obligations of states, the Oslo Principles, and of enterprises, the Principles on Climate Obligations of Enterprises. And since a lot has happened, recent IPCC reports, new research by other climate experts, further depletion of the already limited carbon budget, to mention just a few highlights. And we strongly believe that our current principles no longer suffice. Hence, we have been working on an update that will be published at the end of this year. And I now have to condense 49 principles and over 250 pages of commentary into a few minutes. The primary reduction obligations of enterprises are linked to those of the states in which they operate. And the reduction obligations of states are based on the global carbon budget per capita. And needless to say, the lion's share of the reductions must be achieved by enterprises in affluent countries. It would, however, be against the odds if most states and enterprises are going to curb their emissions to the extent required. In addition, climate science is in the dark when tipping points will be passed. That could be anywhere between tomorrow or by the time we pass the threshold of 2 degrees. Nobody knows. That means that we should not confine ourselves to direct emissions, but should also focus on other trajectories that might help to reach our goal. And that means that we should also focus on suppliers, products, and services, very much in line with a strongly emerging view that enterprises bear responsibility for Scope 2 and Scope 3 emissions. And the focus on products and services, and also of major retailers, is important. Also because it means that for practical purposes, you also take into account the emissions of natural persons. The update introduces obligations of buyers of fossil fuels, which we believe is a more promising approach to get rid of fossil fuels as soon as possible. Governance is extremely important, and we also introduce a series of principles to the effect that boards of enterprises must take appropriate steps, concrete appropriate steps to cope with the challenges of climate change, which otherwise will jeopardize the enterprises and society at large. Seeing the apathy of the greater part of the corporate world, we must explore strategies to bring enterprises to their senses. Next to investors, accountants, credit rating agencies, insurers, and attorneys have to play a role to stem the tide. Accountants can't do a proper job, and they currently don't do a proper job, if they don't have a clue and don't want to have a clue about the obligation of the enterprises they have to audit. Without such an understanding, they can't assess, among many other issues, the liability risk and the reputational risk of the enterprises they audit. Accountants, credit rating agencies, insurers, and attorneys can't escape researching the legal obligations of their clients, their rated or insured enterprises. They do not only have fiduciary obligations towards their clients, but also towards those who, as they know or should have known, rely on their opinions or reports. Our update aims to provide concrete guidance about all those issues. Of course, we realize our principles are not law. They are an interpretation of the law as it stands or will likely develop. Our aimed audience may arrive at the conclusion that our assessment is mistaken. It would, however, be completely irresponsible for many reasons to bet on the idea that enterprises don't have concrete obligations in the absence of pertinent black letter law. It would also be a mistake to believe that many courts will not be willing to come on board. That may be the case with a few, perhaps more than a few in the short term. But one of the niceties of climate change as a global issue is that enterprises can often be sued before courts in multiple countries. So don't bet on judiciary in your country and believe, well, we are safe. You are probably not. Human rights law is important as an underpinning of our principles. But next to human rights law, we also focus on many other sources: environmental liability, company, soft law, such as codes of conduct, governance, principles, all kinds of declarations, and so on and so forth. Authoritative reports, such as David Boyd's brilliant Safe Climate, refer to our enterprises principles. Our website is visited daily by people from around the globe, from all European countries, almost all Asian, Latin American, and many African countries, and of course the US, Canada, Australia, and New Zealand. Some international law firms explicitly refer to our principles on their websites or otherwise. The choice between hugely insufficient measures or compliance with legal obligations like our principles is not the choice between the devil and the deep blue sea. For now, compliance is possible and is also affordable, as recent reports illustrate. The alternative is the devil and the deep blue sea. It is really astounding how many people seem to believe that that is an attractive option. Thank you very much indeed.
Thank you very much, Jaap, for this very interesting and compelling overview. And shall we try to restart the David Boyd video, so we have all the contributions? We should say that there is just a couple of minutes at the end that is another technical problem, but it's not on our side. So let's try to work. No, now it's not working again. So
Ivano, you are on mute. Sorry.
Yes, sorry. I was saying that we can start with the question, because I think that it's not possible to wait anymore for this, and probably we just send you the link we will send the link with the WeTransfer with David Boyd's presentation. So let's start with some question. Yeah, Liz, please.
Sorry, Ivano. I thought maybe I could. I've gone through the questions, and I just wanted to flag that there are some individual questions that are actually aimed at Stuart's presentation and Caroline's presentation. I don't know if you can see the questions, but it might actually be easiest for you to respond. They're asking about specific treaties, etc. And then I was wondering, Ivano, if I should maybe just pose two of the questions that I've seen here to the speakers more generally. The first one was obviously the first question here that's basically saying if companies change their practices to reduce climate change related impacts, they also need to assess the potential human rights impacts of their new practices. And in some cases, these could conceivably be serious. And that obviously ties in with the UNGP's understanding of due diligence as well, which says that if you terminate relationships, you also have to take into account the impacts of that. So I was just wondering if anyone has some thoughts on that, which I'm sure is a theme that will come in the next episodes as well. And then I also just wanted to refer to Clotilde and to Jaap's presentations and some of the other speakers in terms of existing principles, the climate change principles, the non-binding guidance on the EU Financial Reporting Directive, the French law, etc. And I was just wondering, this is sort of a bit of a hopeful question, but if we look at due diligence as a standard of expected care, and the way we understand it in other areas of law, and in this area of law, once it becomes a law, is that existing standards will be key indicators of what can be expected reasonably, particularly because this is already being done, this has already been looked at, etc. So would you say that we are right now, that there is some sort of vision where you could, if you look at the acts of a specific company under specific circumstances, would you be confident in your role as experts in this area to cast the dice one way or the other and say, I'm confident this company has done something reasonable with respect to their climate change, and another company hasn't? And I asked this a bit tongue-in-cheek because I know that there are a lot of cases in the middle where even courts have trouble deciding. But one could have sort of a Platonian vision of what is reasonably expected, and then obviously extreme size of good practice versus terrible practice. So I was just wondering if you and the other experts on the panel would perhaps be able to cast your thoughts on that. And then Ivano, I will also there's some more questions here which I don't know if you wanted to run through that.
Yes, perfect. We leave the possibility to the experts to answer this question, and if you want, I can propose some of the questions from the attendees. Yeah, please.
If it's okay, I'd really love to take that first question, just with a bit of a concrete example that we're coming up with in our work. So the global economy works in a very specific way. So it's basically, you've got a bucket of commodities, and if you take oil companies, you reduce your holdings in oil companies, you're going to look for a similar product in the financial market. And so one of the things that we see is, for example, the price of oil and the price of agriculture is linked. So what we're seeing kind of anecdotally is that as businesses start to draw down the money that they hold in fossil fuels, that money has to go somewhere. So where is that money going? So we're seeing, for example, on also damaging for the climate, issues of agribusiness, which are linked to deforestation specific companies. You can see that the holdings in those companies are increasing. And part of that's because there's a lot of money in fossil fuels, and even if just a little bit of that money goes into agribusiness or agriculture, that doesn't have much money in it. So you're having more money flow in. So what that means is that if an agribusiness company which is not doing its due diligence, which is not acting on environmental harms, on its impact on climate change, is having investors waggle their fingers at it, saying, we're really worried about your climate change impacts, but then it's seeing this huge wave of money coming into the sector, it's not going to take them very seriously. So, you know, at the same time, we don't want to create a situation where businesses are saying, look, we're taking our money out of fossil fuels and now we can't put it anywhere. What are you saying? So I think we need to think really carefully about, you know, for ourselves, we're thinking, you know, if some of that money is being drawn down from fossil fuels, can we say at least have a ceiling on your agribusiness? So don't put any more money into, you know, particular industries and sectors that the IPCC and others have said are really problematic. So I think that's kind of one example. And it also, I think when we think about what laws that respond to climate change need to do, we need to think really carefully about what the economy is going to look like in 10, 20, 30 years, what that means for power, what that means for transition, and to be engaging with that as we think about some of these standards and measures of however due diligence may be incorporated into future laws as well.
Thank you very much, Shona. And we have a few questions for Jaap. First of all, if the next version of the enterprise principles consider responsibility of enterprises to remedy climate harms in accordance with the UN GPS. And then another question is, when this principle will be released, if they will be released soon. And always for Jaap, thinking about the financial sector, what do you see as the role of insurance companies? Thank you.
Thank you. Well, we don't express a view on liability for damages. Speaking for myself, I strongly believe that is a non-starter, at least fully fledged liability is a non-starter. It's simply unaffordable and would have the very unattractive consequence that the people who have caused the problem will be compensated, and once again that poor people will be left uncompensated. Well, that for practical purposes is what will happen if victory will be on the side of many of the American plaintiffs. They will not appreciate what I'm saying now, but it's true. We simply don't have enough funds to compensate all current and future victims. Sorry, your second question. Can't hear you.
Sorry. When will be released the enterprise principles, the new one? Well, they will be released hopefully in November, certainly in December, if not November. And at some stage in the future, they will also be put on our website. And once again, we do not claim that what we are saying is perfect. We accept the possibility that we are mistaken in one or more respects. But we very strongly believe, all of us, and the 87 distinguished endorsers, among them Supreme Court justices from all continents, that it is simply not true that enterprises don't have discernible legal obligations. Perfect, thank you very much. And there is a question for Clotilde. In your view, what are the most effective legal strategies, and how would you assess them as more effective to combat deforestation, thinking of the supply chain?
If I have to say a word indeed on particularly on deforestation, I think we are seeing great opportunities, both in the EU and in the UK. We have two ongoing processes to see the light of upcoming legislation in relation to deforestation. Those two processes are separate, but they are worth mentioning. In the UK, since the end of August, there is a public consultation which is running where the UK government has developed a legislative proposal with and they wait to receive the input of stakeholders to see how a new law to address illegal deforestation could be integrated into this into the UK legal framework. I think it's an interesting opportunity for people to give their views, and they are relying on a due diligence system for companies to ensure that they don't put product on the market from the proposal. It's only targeting illegal deforestation, where I would like to see illegal and sustainable criteria to be included, but that's another question. And I think it's important that they are really looking at what has worked for the EU, for the UK timber regulation. That's how we call it now, which was one of the first tool which was really relying on due diligence system. And we have those 3 steps of identification, assessment, and mitigation. I think what is interesting in relation to deforestation and this process is looking at the facts we are looking at a specific product to ensure that commodities are not placed on the market if if they are coming from sources attached to deforestation. For the EU process, it's also quite interesting because there is also a commitment to come up with a legislative proposal to address deforestation and this legislative proposal should see the light in 2021. There is also a consultation ongoing, which is live since I think the 3rd of September. And here it's a bit of a different process because they haven't, the European Commission has not yet decided to take on the tool of due diligence to address deforestation. They are in the process of assessing which type of tool could be used. There is the option, of course, of due diligence, which is my inclination to address deforestation so that we ensure that product associated with deforestation. And it's also very important to highlight the fact that it should be deforestation and human rights violation. If you can't reach a negligible risk of your product not being associated with deforestation of human rights violation, you should not put it on the EU market. So you have those 2 processes. Hopefully we'll see upcoming due diligence legislation on the deforestation front. I think we see here a very interesting component in relation to due diligence and the fact that we should not forget that the environmental matter and human rights matter when we talk about deforestation is absolutely interlinked, and we cannot do one without the other.
Thank you very much, Clotilde. And there is a question for, I think, I would say for Stuart, but it is no, I take this one is for all the panelists. Do the panelists see ICSID as having a role to challenge fossil fuel companies if they break national law?
Maybe I could start to answer this question. Others could feel free to jump in as they wish. So ICSID itself is the dispute resolution framework through which investor-state arbitrations can be heard. It doesn't have its own sort of detailed applicable laws in relation to environmental standards, etc. It's a framework. It has laws around jurisdiction and jurisprudence around jurisdiction and other matters, but it just sets up the framework through which dispute will be held. So it's really for the parties to bring the dispute through the ICSID framework. And then the question about its relevance really applies to what law would be applicable and who the parties would be. So it could be possible for a state, for example, to bring a counterclaim in an ICSID-based dispute in relation to certain national laws that have been breached against a fossil fuel company, if that relationship sort of materialized into a dispute for whatever reason. So to my presentation earlier, maybe the company failed to adhere to the standards of environmental impact assessment or didn't continue with an ongoing environmental management system or something. in the context of the Morocco-Nigeria BIT I mentioned. So ICSID itself won't do anything. It's a framework for parties, companies, governments to work under in the dispute resolution process. Unless others want to jump in, I might answer the second question about BITs. Should I do that? Okay. So there's another question about whether states could use BITs to derogate from human rights obligations. There are actually many aspects, many layers to in a response to this. As a starting point, I would say that not so much derogation, but this is the fundamental problem with investment law, is that it was developed and grew up in a silo to human rights law and indeed climate change law and most other things. But over time, as the body of jurisprudence and practitioners have developed and matured, there's been much more integration between those domains of international law. And it's generally accepted now that there is one body of public international law, and it's all interlinked, and you bring in the bits as relevant, perhaps rather than a more traditional view where it was, economic law, environmental law, human rights law, they're all segregated. They're all interlinked, but their relevance and applicability to a particular dispute matter, and they won't all be relevant at the same time. So that's just sort of the structural background issue with what we have. But adding to that, BITs historically have been entered into to increase standards of protection afforded to foreign states. It was really born out of the increasing protections post-decolonization in the 70s and 80s, and the perceived concerns that maybe new judicial systems won't be as strong and robust as the more established Western systems. And so this layer of international economic protection was created. So in most instances, the protections which are afforded, and they're reasonably narrow, have increased rather than decreased. Be that as it may, states are still bound by minimum standards of customary international law obligations in relation to human rights and other things. So there's a floor which you can't really go under, and an international tribunal, or go below rather. And an international tribunal would certainly enforce that if it was relevant, in parallel to or separate to the BIT itself, the content of the BIT. Another point I'll make is that increasingly large multinationals will be bound by the extraterritorial effects of human rights legislation from their home countries. So if you're a big oil and gas company based in England or France or elsewhere, as that law develops and you have operations offshore in different jurisdictions, you will still need to comply with your home country human rights obligations. So if the host state in which you're operating has a lower standard, that doesn't mean you can reduce your standards as well, because you still have obligations based on your home state requirements. And that may or may not play out in the BIT. And the final point I'll make is that, which is the point of integration of different domains of international law, we really see this playing out in the renegotiation of BITs and the creation of next generation or new generation BITs. The wording is much broader, it covers many more topics, it's much more specific. Issues like human rights, climate, environment are being expressly dealt with, as are the limitations of the protections afforded to investors and the scope of a state's rights. So the right to regulate, for example, in some new BITs and model agreements, that's being very expressly articulated, including around environmental regulations as well. So I would say that overall, where the whole regime is being more inclusive of these broader modern imperatives around human rights, climate, environment, etc., than less inclusive.
Thank you very much, Stuart. And we can take another question for Caroline. There is a question whether the oil and gas sector is discussing in sector jurisdictional landscape approaches. Caroline?
Sorry, thank you. Sorry about that. So it kind of depends on the issue in many respects. There's a lot of focus at the moment on water within certainly amongst the European based companies. Remember, the oil industry is very globalized. It's also very much affected by state oil companies, by companies based in parts of the world where there aren't the same regulations and there aren't the same requirements. So it's very variable, but yeah, I mean, BIICL is very focused on things like water and the impact of dealing with water stress regions. So it's very variable in terms of issue, but there are focuses on climate change impacts in particular pockets.
Thank you, Caroline. And we can take another one. I think the last, there is a question, I think for all the panelists. Do the panelists see climate change due diligence as an additional process for companies to undertake, or rather this should be subsumed within a broader and a comprehensive due diligence process that looks at human rights and environment, very broad? Whoever wants to take this.
No, may I?
Please, yeah.
Human rights are very explicit if you're talking about, say, torture and child labor. Human rights are not explicit at all if you are talking about climate change. And so you have to try to interpret what human rights mean in that respect. And well, that is the kind of discussions we really need. We should, with due respect, stop talking about in the abstract about, well, human rights this and human rights that. Yes, human rights are important. They could play a very, very useful role. But we really need a much more concrete debate.
If I can jump on that one as well. I think what we see, and if you look at some of the due diligence tools often used by the financial sector, you have like a score out of 10. And it's like, okay, this company got 7 out of 10. And even if you look at like big oil companies, they're like up there because the way that those things are weighted are like, oh yeah, they got a really good governance score and they've got women on the board. And like, I think it's important when we talk about how we look at due diligence that we also talk about thresholds. Like, I think there's a real danger that we'll end up with this, like, it just kind of put everything in a bucket, and if you get over a certain point. And I also think there is like this sense from industry at sometimes is that they just want to keep investing in bad stuff, and so they will come up with these arguments about like, well, you know, what would happen if we took our money out of all this bad stuff, and I think it's really important for us to keep that as a goal and to think about that as accountability as well.
Thank you very much, Shona. Our time is up. I think that I have to thank to everybody. Thanks to our excellent speakers, thanks to Liz, and thanks to the audience, to the attendees for the questions and for their attention and patience also. Sorry for our technical problems. As I said, we will send you a link with David Boyd's presentation, and we welcome you next week for another episode, the second episode of this webinar series. And will be on climate litigation. So Liz, if you want to say something.
I just wanted to say thank you very much to all the speakers and to all the attendees. And we look forward to hopefully see you next week. Thank you.
Thank you. Bye-bye.